Hi, my name is Sergei Kuchinski, the founder and principal attorney of the Kuchinski Law Group. Today we're going to be talking about a trial strategy for a second DUI offense. When it comes to DUI offenses in the state of Illinois, for the second DUI, there's really not much of an opportunity to do anything in court but to plead guilty or to take a case to trial. The law prohibits one to receive another court supervision for the second DUI offense or get it reduced down to reckless driving if that specific amendment has already been granted in the past. So realistically, it's either take a conviction or take it to trial. My personal opinion, if the case is worth taking a shot, we should take that shot. And we should take that shot at trial. For the second DUI offense, granted, one can go to jail up to 364 days in jail. However, there is good possibility that one will be let go and be found not guilty. All depends on facts and circumstances. One of the cases which we handled relatively recently, we got our client not just a not guilty, we got it directed out, meaning that the state wasn't able to prove their case on its face. Not enough evidence were presented by the state attorney's office, and not enough testimony was solicited from the police officer for the judge to establish that my client actually was under the influence of alcohol while operating a motor vehicle. All of that can be established in a relatively easy, simple fashion, so long as you have a plan, a strategy, and you're methodical about it. It's important to understand the elements of a DUI. One must be under the influence of alcohol and an actual physical control of the vehicle. Intoxication can be proven by certain facts such as glassy and bloodshot eyes, odor of alcohol, slurred speech, or inability to maintain balance, present coherent speech, or lack of dexterity. All of those things must be hit on methodically during cross-examination and see if the state is able to establish intoxication, to see if the officer actually witnessed something that the state alleges. And it's important to know everything that was done during the course of the investigation in order to be able to break it down properly. Law is very specific and states that X, Y, and Z must be done in order for the state to meet their burden. Each and every element must be met beyond a reasonable doubt. And what we did for our client, since we didn't have much of a choice, we had to take it to trial. We had to create a very specific trial strategy, take it to court, present it to the judge, and fight for our client, breaking down every single argument and every single element that the state was presenting as a fact. Ultimately, the judge granted our motion for directed finding and threw the whole case out because the state was unable to establish a pattern of mumbled or slurred speech, glassy and bloodshot eyes, odor of alcohol, or inability to perform field sobriety tests. Knowing all of that and knowing how the court operates, knowing the law, and knowing when to make arguments, when to make a very specific argument, and what to say at a certain time in court makes a world of a difference. Trial strategy should not be taken lightly. It should be taken seriously. Trials take a lot of preparation. It's not open up your report and wing it. It's days and days and days of preparation, explaining everything to your client, and making sure your client understands what you're doing, and more importantly, why you're doing it. Once that's established, it's very easy to actually go to court, do a bench trial, and have your client sit right next to you, understanding each and every word, each and every argument that you're doing, not just from the legal standpoint, but from the point of why it's being done and why we created that specific defense for our client. And ultimately, when you play your cards right, you're gonna get a not guilty.